Hello, everyone. Happy Thursday. If you're tuning in live, this is the latest iteration of the Psychedelic States of America Advocacy Spotlight Initiative with a special federally focused edition for you all today on a pretty special occasion, as this is our first official co-live stream with the great folks at High Times Magazine. And this marks the first interview focused on psychedelics that High Time has aired since their very exciting relaunch in recent weeks. So before we get started, I just want to note the historic nature of that as a publication that has been around for a long time under many different ownerships and has a lengthy history of daring journalism in the independent space, both when it comes to cannabis, but also a long tradition of psychedelics coverage. And many of my own favorite writers and reporters have worked for and had bylines in High Times Magazine. So thank you to Javier Jose, editor-in-chief at High Times currently, and owner Josh Kesselman for this opportunity. We're certainly especially grateful, and I am truly honored to be joined today by the legal team behind a daring and multi-year effort to reschedule psilocybin, for those unfamiliar, the psychoactive compound found in what is known as magic mushrooms. Kathryn Tucker and Shane Pennington, who have led a truly historic effort, most recently advanced by the DEA, not without a legal fight behind it to nudge them there, which we'll hear more about soon. But the DEA has recently forwarded their petition to reschedule psilocybin from Schedule 1 under the Federal Controlled Substances Act to Schedule 2. They forwarded that petition to HHS, the U.S. Department of Health and Human Services, for review and potential recommendation. So without further ado, Kathryn and Shane, thank you both so much for being here. Would love to get the basic, as we talked about in the lobby, the Zoom style icebreaker. What your background is, what got you involved in this particular area of law, and then how you two came together to lead this fight. Kathryn, love to start with you.
Yeah, thanks so much, Jack. And long story short, I have 37 years under my belt at my day job as an attorney and an advocate. And my work is focused on advocacy to protect and expand the rights of dying patients. And that's involved a lot of different things over the years, but about 5 or 6 or now 7 years ago, I was taking interest in the modern era clinical trials showing that a single guided psilocybin session would bring immediate, substantial, and sustained relief from anxiety and depression to people in advanced illness. And from working so long in the field, I knew that that was filling a gap in the palliative care toolbox, because we had made so many strides to relieving pain and other distressing symptoms and empowering patients with more choices. But what was missing was a tool for relief of non-physical suffering. And that's what psilocybin offers. So when I was reading about that, I got very interested in turning some advocacy toward opening access. And I had come to know Dr. Sunil Agarwal because he came to a big conference that I was involved with convening at the University of Washington School of Law in 2017. And he is a palliative care, hospice and palliative care specialist physician in Seattle. He has an integrative oncology clinic called the Advanced Integrative Science Institute or Medical Science Institute, AIMS. And he wanted to be able to offer psilocybin therapy to his patients. And so I started working with him to brainstorm ways that we could do that. And I started with the concept of using right to try laws, which we'll probably talk about a little bit. And as I was putting that together and building a legal team to represent Dr. Agarwal in that effort, I was introduced first to Matt Zorn. And then Matt, of course, is very close with Shane Pennington, and Matt brought Shane on, and the three of us have been kind of core part of a rather large legal team. And then, of course, as you know, Matt Zorn has gone over to HHS to head up the psychedelic division. So he's not on our team anymore, but he was a key player as is Shane. So that's kind of the background in a short overview.
Shane, we'll pivot obviously to your origin story to this point as well here in a second. But for a quick overview for those who might not be familiar, Matt Zorn is current deputy general counsel, if I'm not mistaken, at the Department of Health and Human Services, and was brought on not long after starting and being involved with the charge, both the reschedule psilocybin as well as cannabis, which Shane, you have been involved in as well. Now working for the Department of Health and Human Services, he has recused himself from being involved in these proceedings, but has been called the psychedelic czar and even been lumered, for those who may know, as well as my good friend Josh Hardman over at Psychedelic Alpha when he first reported that scoop that Zorn had been brought on board. So knowing that there is a pro rescheduling ally within the ranks, as well as someone who's being grilled at the Senate level today, RFK Jr. in charge, is a fascinating thread to what may come next. So Shane, without further ado, tell us a little bit about how you and Matt came to be involved in this case in particular, and what led to teaming up with Kathryn, and what may come next.
Sure. Thanks for having me, and thanks to everybody who's viewing. So if you go back to basically 2018, Matt and I were both litigators at a boutique firm called Yetter Coleman in Houston. We had different practice areas. Mine, I focused on appellate work, Supreme Court cases, and particularly cases involving federal agency action. And it was all very nerdy and very, very boring. No one ever paid attention to anything I was doing except the parties in the courts involved to that point. And then Matt, who I knew but had never worked with, one day came to my office and said, "Hey, I went to South by Southwest in Austin and met a doctor named Sue Sisley, who's wanting to study basically dispensary marijuana, and she's applied to DEA to be able to grow it in a federally legal way so that she can study it for veterans with treatment-resistant PTSD. And DEA has just refused to act on her petition for years, and she needs pro bono legal assistance." And Matt came to me at that time because then, at least, he hadn't done any administrative law work in his career to that point. It wasn't the focus of what he did, so he wanted to bring in somebody who focused on that to be able to help. And I said, sure, and we ended up winning that case for Dr. Sisley after some pretty long litigation. In the process of winning that case, and it was really my first exposure to the Controlled Substances Act, to the Schedule I predicament, to the book barriers to research, to many things that are now daily focuses for me.
Yeah.
And I realized, man, this is a target-rich environment. This work is really meaningful. There's a lot more to do here, and so I sort of shifted my career that direction. And it was right at that time that we had represented Dr. Sisley, that Matt met KT, call her KT, and he said, "Hey, there's another case that I think we should take," and really grateful that our firm at the time let us do that. We've both since left to do other things, but it was a really important part of it was that we had a firm behind us that let us take these cases on pro bono, and we got involved then.
Yeah, so Kathryn, I know you've done some work, and it's noted obviously in your tagline that you're the advocacy director for the National Psychedelics Association. Really interesting organization that is evolving in real time, but has played a role in your efforts to this point. Talk a little bit about what NPA is and how their work in this space has benefited both your efforts and, as we've seen, other efforts that they've been involved in at the state level.
Yeah, so the National Psychedelics Association is a relatively new 501c3 nonprofit, and it has the goal of being supportive to those who are in the arena of providing psychedelic assisted care. So, while we're talking primarily about federal advocacy today, as you may know, Oregon and the states are not waiting for the feds to reform. And so Oregon adopted the nation's first psilocybin services act in 2020. I was involved with the effort to see that across the finish line. And really, it was when I was working on that campaign that I realized that even if it was successful, states can only change state law, and there would still be a federal barrier, a federal prohibition. And in fact, it's a federal crime to do anything with psilocybin other than research at this point in time, given its site on Schedule 1. And so that's what really catalyzed my work to find federal safe harbor. But the NPA is supporting businesses in Oregon and now in Colorado that, under the auspices of a state legalized and regulated program, are opening businesses to manufacture and dispense and administer these drugs. Colorado's bill is wider in scope than Oregon's. Oregon's is just about psilocybin. Colorado has a broader range of substances. And so this organization is kind of a platform of support for the businesses that are kind of boldly going forth where there is a state safe harbor, but not a federal. And when I saw that group kind of beginning to stand itself up, I thought that the advocacy that I had started could be done from that organization, because our interests are aligned. We're really about being able to see psychedelic assisted care available, safe, legal, regulated. And so that's where I am currently doing this work from now.
Amazing. And, to that point, you mentioned that you first got involved in this petition effort, which we will get to the step-by-step process of how you even go about making this request of the federal government. But you mentioned that your background really in getting into this space was with working with dying patients, which I think is an area of psychedelic advocacy and the potential benefits of psychedelic assisted care that, as we look at headlines across legacy media organizations, is not really as well represented as we see, rightfully so, a lot of focus on veterans, folks struggling with addiction, but those who are already dying, we often think of physical ailments, but the fear of death itself is very real. You've also been involved in some legal work challenging the state of Oregon's restrictions on at-home care for dying and also homebound disabled patients. How has that process differed, that lawsuit, from this petition process? I am curious.
Yeah, well, in Oregon, and again, let's remember, it was the pioneer to adopt the nation's first state legal program. And often the pioneer has made some mistakes in their first time out of the gate. And one of the things that I think was an overlooked aspect in the Oregon law is there was no provision for reasonable accommodation for disabled people who are so unwell that they cannot leave the home. And, I did spend several years as the executive director of a national disability rights litigation shop in LA called the Disability Rights Legal Center, and have been very attuned to the rights of disabled people. And so when I saw that Oregon restricted psilocybin services to service centers with no accommodation for homebound, disabled, and dying Oregonians, we did approach the state about the need to have reasonable accommodation. The state was not willing to make that. And so we did file a federal lawsuit pending in Oregon called Cusker versus OHA, where under the Americans with Disabilities Act, we're seeking reasonable accommodation for homebound Oregonians. We did have a really important initial ruling. The first thing the state did was try to have the whole case thrown out on the grounds that the substance at issue is federally prohibited, notwithstanding that Oregon is running a whole program with this federally prohibited substance. It wanted the courthouse doors to be closed to the case. And the judge said no, relying on cannabis precedent, that we're going to see that there be access for disabled people. So the case is moving forward. I'm really happy to say I also just worked on the first legislative enactment of a psilocybin bill down in the state of New Mexico. Oregon's bill was adopted by initiative, which is by the people. But in New Mexico, the legislature took it on. And in one session, we succeeded in passing the New Mexico Psilocybin Services Act. or it's called the Medical Psilocybin Act. And it's quite different than Oregon's. It's not adult use. It is medicinal. And it provides for the care to be provided in what the clinician believes is the appropriate setting. So for a homebound, disabled, or dying person, that would be in the home. And I'm happy to see that no one's making the mistake that Oregon made.
Yeah, those who might be familiar with the interview series we've been running since back on 420 back in April, our first interview was shortly after the governor of New Mexico signed the Medical Psilocybin Act into law with a great host of local advocates that had been involved in the push. I think is what's really fascinating, and I'd love to continue to follow before we get back to Shane to discuss how you go about doing this. There's an opportunity, given the way you just described, Kathryn, that the setting is defined best by the practitioner. That also allows for the facilitation of Indigenous practitioners and those who've been working in this space, for both decades, years, etc. If those semi-underground or underground, places are appropriate, I'd be, curious to see how that turns out. So excited to continue to follow what's going on in New Mexico. Last week, we interviewed the Alaska crew. They're gearing up for an exciting 2026 ballot initiative. But as we say often, the political landscape is rapidly evolving when it comes to psychedelic policy reform. So, Shane, back to you. You came into this space not having any reference point for how to go about lodging a complaint with the federal government, lodging a petition. Tell us in layman's terms, for those who might not know, where do you start? Obviously, it started when Matt Zorn came into your office and said, "Hey, I've got a case for us." But how do you go about making that request?
Jack, I am so sorry. I could not hear your question. Something's going on. I may have to rejoin, but could you repeat it? Let's see if I can get it the second time.
No worries. Can you hear me now?
Yes.
Okay. We are hoping you can just provide some insight into what step one in the process of lodging a petition to reschedule any controlled substance is. Where do you even start with a process like this?
Sure. So in this case, there was like a big backdrop and a multi-year legal battle that transpired before we actually drafted and filed the petition, which we can get into. But to start with how you do it, rescheduling petitions are governed by, it's an extremely complex process laid out in the Federal Controlled Substances Act. It's actually a formal rulemaking process, which is extremely rare under federal law now. It used to be much more common, but it's so complicated and takes so long, and there are so many nuances to it that over time Congress has moved away from it. But it stayed in the Controlled Substances Act as like maybe one of the last refuges of it. I think in a 2015 Supreme Court opinion, one of the justices referred to it as the Yeti of administrative law because it's often talked about but seldom actually seen. And so I'm giving that intro so that you understand, like, it's a very, very complicated process, and I'm going to have to simplify it, otherwise we'd be here all day. But basically, any interested person can submit a petition to reschedule. It goes to DEA. DEA can then, and often does, just deny it at the threshold. But if it thinks that there's any basis for it at all, then it will request the scientific and medical evaluation from HHS and the scheduling recommendation from HHS. And so there's a complicated set of factors that the agencies consider there. But eventually, when that happens, HHS will weigh in. It'll have its analysis, and that analysis will include medical factors, scientific factors, all the evidence that's available. And then on the basis of all of that, under the considerations required by statute, HHS will say, hey, we think it should be in this schedule or that schedule. That goes back to DEA. At that point, DEA will decide whether to issue a notice of proposed rulemaking, which is like the starting point for the actual rulemaking process. And that's a public document that gets published in what's called the Federal Register, which everybody can see. And so that then launches the public comment period, which is followed by hearings, and eventually you get a final rule. But the beginning point is this petition. And so, we filed that. I forget when the exact date was, but at this stage, just to be clear about where we are, we filed the petition. There was litigation over it when DEA just denied it out of hand. They just slapped it down very quickly in a one-page letter. We challenged that in federal court. The Ninth Circuit said that denial was unlawful, and then remanded, sent it back to the agency to either give better reasons for the denial or move the process along. And gratefully, DEA decided to move the process along and send the petition to HHS to get the process going.
Amazing. Yeah, for those who may have tuned in earlier this summer, we did a really great interview with Hamilton Morrison, Robert Rush, and Brett Phelps, co-counsel on this essentially process somewhat in reverse in the effort to stop the scheduling of two lesser-known psychedelic research compounds, DOI and DOC. That process started with DEA forwarding, asking HHS to draw up a recommendation for whether or not these two substances should have been scheduled. And from there, the co-counsel, helped in part by the great folks at Students for Sensible Drug Policy, filed a petition for a hearing to combat that effort to schedule them. This is, you're saying, essentially the opposite. You guys led the charge, requested an opportunity to be heard, requested an opportunity for the DEA to evaluate the possibility. They flat out deny it. And so you all take it to court, take it right to the DOJ. They rule that you have a right to be heard. So what in this process, as far as how the HHS breaks down their recommendation, what comes next?
Well, one of the things, I want to jump in and say one of the things that's really unusual, I think, about where we stand today, and, that was a great overview of like where we stand. The fact that the petition has gone over to HHS, it's not gone over there to be in a vacuum, because we know already with the two prior breakthrough therapy designations that have been given to psilocybin by the FDA, that a close medical and scientific evaluation of this investigational drug has already been done.
Yeah.
And breakthrough status is only granted when the agency comes to hold the view that this investigational drug has benefits beyond what already approved drugs have. So, our optimism, I'm always an optimist, but our optimism about the fact that DEA has now done its job and advanced the petition over to HHS, HHS confers with FDA on the medical and scientific review, is that they can quickly say, yeah, we took a close look at this. We twice gave breakthrough status. We are ready on a pretty accelerated basis to get this back to DEA with a favorable medical and scientific review and the recommendation that it come off of Schedule 1. So that, I think, is important to keep in mind with these moving pieces.
100%. And Schedule 2 is very different than even what has been explored with what Schedule 3 provides. So, Kathryn, could you spell out to us what a Schedule 2 designation for psilocybin, what would change, both in terms of access medically? Would people be able to go buy psilocybin in a cannabis dispensary? What would this actually lead to? Because
Shane should certainly comment on this, but I'll just say, if it moves to Schedule 2, people like our client, Dr. Sunil Agarwal, who holds a Schedule 2 registration with the DEA and uses it to access drugs that he provides his seriously ill patients, he would be able to access it. And this is going to open our discussion into another area that we've been battling with DEA. He would be able to access it even prior to FDA approval under right to try law, which is a federal law and also has been adopted in a supermajority of states that recognizes that people with life-threatening conditions don't have the time to wait for the long process of new drug approval to wend its way to completion. And for that population, access prior to approval to certain investigational drugs is to be allowed. And psilocybin meets the criteria to be accessible under right to try.
Yeah, I know that that's been something that's been debated a bit in the psychedelic sphere. And Shane, I'd love to hear from you a little bit. One, in response to those who might say, hey, the Right to Try Act, as it was written, doesn't extend to controlled substances. What would you say to critics of this particular legal argument?
Well, first of all, in the state statutes that Kathryn alluded to, many of them do expressly say that access to even Schedule 1 drugs, as long as they're qualifying eligible investigational drugs, should be permitted. The federal government and several other state laws don't expressly make that clear. But what the statute does say is, here's what an eligible investigational drug is, and it defines it in a very, very clear way. And it says what it is and what it is not. And in that description, it does not say anything about it being Schedule 1. And something important to understand here is people need to get that in our system, once a drug is FDA approved, that means it has a currently accepted medical use, so it can't be in Schedule 1. The only way a drug could be in Schedule 1 is if it has no medical use and it has this high potential for abuse, okay? So what we're talking about are investigational drugs, which means they don't have FDA approval. And so they don't have the traditional signifier or qualifying characteristic for currently accepted medical use, right? So you're not going to find, an investigational drug in Schedule 2, 3, 4, or 5 because they wouldn't have FDA approval and they wouldn't be there. The only controlled substances that could be in eligible investigational drugs are going to be in Schedule 1. Otherwise, they wouldn't be controlled substances. Let me give you a concrete example to illustrate why this is so important. Imagine a drug twice as dangerous as fentanyl, right? Just a super duper deadly drug. But imagine that it also has, it hasn't been discovered yet. It's laying out there in the woods somewhere for somebody to discover, right? And imagine that this drug is has the potential to be an eligible investigational drug, meaning it has the potential to help people with a life-threatening disease or condition. And once that drug advances, because it's not been discovered, no one knows how dangerous it is yet, right? Nobody has any idea. That drug would have no barrier like psilocybin has. It would become an eligible investigational drug immediately once it got through phase 1, was in phase 2, and met the conditions under the statute. And Congress obviously knew that. Like that's the nature of an investigational drug, is that we don't know everything that we would ordinarily know about it. It's only by happenstance that these drugs that have been targeted by the federal government, often for very, very disgusting reasons, right? Yeah. They are set apart in this class. That means that no matter how much they might help, however many people with life-threatening conditions, because they've been singled out for these disgusting reasons historically, now they are somehow being cordoned off, even though they are otherwise eligible under the statute. And that makes no sense. And in any event, that is why we have worked so hard to push for this. We've pushed for it directly. We've made these arguments in court. No court has rejected our arguments on the merits because they're good. We've gotten kicked out for silly reasons at the threshold. Now that we've petitioned, we've made a novel argument, and one that has succeeded so far and that we believe will succeed, which is that once a drug has breakthrough therapy designation, like psilocybin has, and it is otherwise eligible because it has shown itself to have gotten through phase 1 and thus have safety in place for use and treatment under certain conditions, that drug has what the statute refers to as a currently accepted medical use with severe restrictions. And those last words, with severe restrictions, distinguish this from the traditional argument that a drug has a currently accepted medical use in treatment in the United States. That's what's going on with cannabis, and that's what people always hear about when they think about Schedule 1. We've locked on to a very much overlooked aspect of the Controlled Substances Act that allows Schedule 2 classifications for drugs that have a currently accepted medical use with severe restrictions. And our argument is that a drug like psilocybin that has breakthrough therapy designation and is otherwise eligible ought to get that recognition and ought to be in Schedule 2. And that's a That's a path-breaking argument, one that's succeeded so far, and that would have massive implications for a host of issues. But most immediately, it would get Dr. Agarwal access to the medicine that he needs to be able to treat his patients.
Yeah, I'm curious to hear from both of you your thoughts on this idea of, FDA approval being, from a pharmaceutical pathway. There's been a lot of talk of the idea of bifurcated scheduling. This idea that synthetic compounds might get approved as a specific patented FDA formula. One company that's been at the center of this for a while is Compass Pathways, who's been involved in legislative efforts at the state level as well, curiously so. Would this rescheduling kind of hinder the possibility of synthetic-only FDA approval? Obviously, synthetic compounds would have to be approved by the FDA, as would natural ones to be deemed, insurable, et cetera. But would this limit the ability to go only synthetic in the future? Would this rescheduling petition include natural and synthetic, or just psilocybin in a legally interpretable way?
Well, so at the moment, the way I look at it, and of course, curious to hear what Shane thinks, but for the moment, our petition to reschedule psilocybin doesn't specify synthetic or fungal. It just speaks of psilocybin in general. But having said that, if we are successful in seeing the movement to Schedule II and access under right to try prior to FDA approval were to open, the stricture on that under the right to try is that the drug must be deemed an eligible investigational drug under the terms of right to try law, which means it has successfully completed a phase 1 clinical trial and remains under investigation. And
Yep.
at the moment in the US, that would be the synthetic version. Now, a couple things to say about that. Interestingly, there have been different behaviors by the manufacturers of psilocybin that is being used in clinical trials. And one of those manufacturers and sponsors has been USONA, which is a public benefit corp, which put its process for synthesizing psilocybin into the public domain, which was an act of generosity. Often, Big Pharma is very careful to preserve intellectual property protection. So this was in the face of that. It just put it in the public domain.
Mm-hmm.
My view is it is possible that if psilocybin moves to Schedule II, the USONA synthesized psilocybin would be an eligible investigational drug, which USONA, as the sponsor, could choose to make available, and we hope it will. But absent that, my view is a GMP lab could take that synthesis process and make the product that is the subject of the IND that USONA has, and that could be an eligible investigational drug. And then also go ahead.
No. Finish what you're saying, Kathryn.
Well, I was going to say, I am aware, and I know you are too, Shane, that Sue Sisley at Scottsdale Research Institute has some fungal trials underway. And what's interesting is those trials could suddenly toggle fungal psilocybin into the status of eligible investigational drug, assuming, the requirements of right to try law are met. So that's also on the horizon.
Yeah, Shane, can you tell us a little bit, because you mentioned Sue, can you tell us a little bit about that particular case where she's now conducting phase 1 clinical trials at the Scottsdale Research Institute with, correct me if I'm wrong, specifically, and excuse my French for the folks at home, Jedi Mindfuck strain psilocybin mushrooms, whole, correct? This is the first ever clinical trial that's been conducted that way.
That's right. And so I'm not currently representing Scottsdale Research Institute in that project, but I'm certainly aware and talk to Dr. Sisley all the time. I do want to loop back to your question about bifurcated scheduling briefly, just so that I can clarify this. People ask about this all the time, and I want to make sure people understand that if FDA were to approve a compound like, say, Compass Pathways compound, and if there were to be bifurcated rescheduling, right? So they were to say this drug formulation that Compass Pathways can profit off of That one is in Schedule 2, and everything else remains in Schedule 1, right? If that were to happen, and then we were to get our petition, which is for psilocybin full stop, moved to Schedule 2 on the basis of currently accepted medical use with severe restrictions, that would mean that for purposes of that severe restrictions bit, for right to try access and perhaps other things, any psilocybin would potentially have the Schedule 2 classification. And yet, for the purposes of full-blown Schedule 2 classification, you would have just the Compass Pathways iteration. If, on the other hand, the FDA approval for Compass's drug were to result in full rescheduling of all psilocybin and not bifurcated, then all the different variations of psilocybin that are out there that qualify as an eligible investigational drug would be available for right to try access, regardless of what happens with our petition. So I hope this is extremely confusing and difficult, but I hope that, you know, people can rewind that and listen to it, because that's basically the way this goes. And the last thing I want to say about it is, I think this entire idea of bifurcated scheduling is illegal. And I've always kind of wanted to bring the right case to challenge it. I don't think it makes any sense, and I don't think it would pass muster under judicial review, but that's an issue for another day. And then back to your question about Sue and her trials. As I understand it, she's about to finish phase 1 there. She's on track. You know, I don't know what the timing is, but I think that, you know, by the end of the year, she should be close. And then all she would have to do is get the phase 2 underway, and her drug would be eligible. And one thing that's great about Sue in particular, another thing that makes her kind of a unicorn out there, is not only that she's using whole fungal psilocybin, but also that she's got her own DEA grow license for psilocybin. Yeah. She also has one for cannabis and LSD, and also, you know, you don't grow LSD, but you can manufacture it. Yeah. She has this full house of DEA licenses that, as far as I know, nobody else has. Yeah. So she's able to do all of this with a very public interest mindset in place, which is something that benefits all of us.
Yeah, I know there are some Canadian companies that have approval from the Canadian federal government to do some of their own growing of certain substances. Cubed Biotech comes to mind, fascinating company. But Sue Sisley is, you know, I think an American psychedelic icon, to put it lightly. And I think the importance of breaking away from the norm, especially when it comes to the University of Mississippi being the only place federally approved to grow cannabis, and it wasn't very good, is so important for research. But one clarifying question I have for both of you, and this is obviously something that is more of a theory-oriented question than it is you may have a definitive answer, but she's using a specific strain of psilocybin, Psilocybe cubensis mushroom, Jedi Mindfuck. Would the completion of phase 1 and the entrance into phase 2 only allow for use of that particular strain of psilocybin? Because there's over 250 for folks who might not know. They just discovered 2 more in South Africa last year. So this idea that they might be confined to this one pretty intense, there's mellower strains, there's certainly much more intensive strains, but we're learning strain matters when it comes to use of certain, naturally derived whole psilocybin mushrooms. Would this confine Jedi Mindfuck as the only one that you can access from a whole psilocybin mushroom perspective? Curious to get either of your takes on that.
We get this question all the time. And the fact of the matter is there isn't an authoritative answer to it yet from any court or from, either HHS or DEA. And there are arguments on both sides. I could go through them, but it would be probably tedious for listeners. I think that, what's that?
I just said it would be onerous, agreeing with you that it would be onerous for listeners.
It would be too much, but suffice to say, it's not crystal clear yet. And that's what makes, again, this whole effort and everybody who's working on it kind of cutting edge and super important, because these sorts of questions are going to be answered eventually.
I mean, my answer to that question, Jack, would be at least for our purposes of speaking of a period of time prior to FDA approval, where what we're talking about is access under the auspices of right to try, I think what you would be required to do is look to the IND for the drug, for the investigational drug. And if it called out a particular strain, then you're probably with that strain being the EID, the eligible investigational drug. But one thing I made a note to myself to make sure not to rush past, that I want your viewers to be aware. And Shane touched on, the process with where we're at now with our petition moving from DEA to HHS. And then when HHS is sending it back to DEA, with DEA then tasked to issue a notice of proposed rulemaking, that moment is a moment which many in your audience may like to be preparing for, because in that moment comes the public comment period. And in that moment, those in the research community, the clinical community, the advocacy community have the opportunity to submit public comment. And I know Shane told me the shocking number of public comments that came in the cannabis rescheduling comment period. And I don't think we'll see that many, but certainly interested parties can put in public comment and should be preparing to do so.
Yeah. Yeah, Shane, do you remember off the top of your head the number of comments? I know it was in the tens of thousands related to the cannabis rescheduling period.
It was over 43,000. If I remember the exact number, I think it was 43,291. But you can break that out. A lot of them were repeats. In other words, some organization would draft up a "We love cannabis" or "We hate cannabis" newsletter or whatever, send it to everybody, and then everybody would flood the inbox of DEA with the same comment. But there were, I believe, 11,000 distinct comments that were submitted. And KT's absolutely right. Public comment period, people don't realize how important it is and how important it is to get prepared, because that becomes the record that is, it's to be a historic public record, the kind of thing that people will look back at to see what was in that. And courts will look at it on judicial review. In fact, they're confined to it. And so if you want something in front of the federal government about this, and you think you have something important to say, you should definitely say it. And you should consider coordinating your efforts so that people have really sophisticated, really coordinated responses. I mean, this is one of the things about this area of law is, like, in my prior life, I worked with major industries, giant companies that had teams and teams of lawyers with teams and teams of lawyers, under them, who would coordinate all this with trade associations and so forth. We don't have that. And it matters, because when it goes to court, courts are used to looking at a certain thing a certain way. And it just, if it doesn't look like a duck and quack like a duck, sometimes they might get the misimpression that it's just not a duck, right? Yeah. And so while I'm not saying that we can't succeed, I am saying that we need to take this extremely seriously. And when you get a chance to swing at a pitch over the plate, you've got to take your shot in exactly the best and correct way. And so, I would encourage people to, and, eager to help people with that to the extent we can.
Yeah, no, I appreciate that call out, having covered, as I mentioned before, the incredibly onerous process that was undertaken by the SSDP Ramos team to challenge the DEA. We're talking about, less than a dozen advocates and scientists who banded together to go into the DEA's HQ and challenge the status quo. And they're playing defense, right? So in this case, we have an opportunity, or at least you all do in the community and support, to play a little bit of offense. And that is rare. I also think it's worth noting, of course, that the speed at which this petition has been advanced, I'm sure in no small part because of the lawsuit waged against the DOJ, but has moved at lightning speed compared to cannabis rescheduling efforts, which continue to be delayed. And
I love that you say lightning speed, Jack, because, for us, it feels like it's been a long, slow slog. But I think you're right. Like, in comparison to cannabis, it has been lightning speed. And I do hope that the psychedelic community writ large does sit up and take notice of this. One of the things I think that has that is a potential advantage is because we did have the rounds of litigation that we have had, both in the right to try and in the rescheduling. We've actually taken DEA through 3 federal court litigations. We did see a lot of participation as friend of the court or amici. And those amici come from sort of such a broad spectrum. We had civil liberties groups, we had conservative groups, we had the whole Veteran Mental Health Leadership Coalition, which is the umbrella group for veterans advocating for access to psychedelic assisted therapy. We had the modern era researchers come in. So we've had quite robust participation in the lawsuits, which has already kind of brought all of those players to the table of this work. And many of them are watching this really closely. And I do want to say, of course, while, our representation of Dr. Agarwal has been about his patient population, which is people dying of cancer primarily, the application of psilocybin assisted therapy to veterans is profoundly impactful and beneficial. And so if we are successful here, veterans who are at risk of suicide due to PTSD will be able to have access in the context of their existing treating relationship with their healthcare team. Veterans will no longer, as many of your viewers know, they have been leaving the country they served to go to places like Jamaica and South America and Mexico. And that's really, as the veterans brief said in our litigation, that's morally reprehensible. So delivery of care to veterans in the country which they served will be accessible if we're successful with this petition. And so we're so grateful to have the veterans groups leaning in with us on this effort.
Yeah, as I've said on many of these live streams before, and I think has become kind of a rallying cry for what we're building at Psychedelic States of America, this is both one of the most fascinating and I believe will be remembered as one of the most consequential political movements of the 21st century. As you mentioned so eloquently, Kathryn, it really transcends as many partisan lines as you can think of, which when it comes to areas of, extremely progressive policy, it's certainly been documented that there are Republicans that lean on the libertarian side when it comes to civil liberties that are pro-cannabis legalization. But as we've seen in recent weeks, conservative stalwarts like former Texas governor and Republican presidential candidate Rick Perry, writing op-eds in the New York Times and in the Wall Street Journal and being quoted in the New York Times as a champion of Ibogaine, there is no movement that generates the broad political support currently, except maybe certain niche foreign policy issues. So really the implications of progress at the federal level.
And Jack,
bring forth. Yes, sir. Chime in, Shane.
Sorry, I still think there's something wrong with my connection, so I'm sorry to interrupt you, but
No worries.
I just wanted to add one thing. You're correct about the bipartisan support, and it's important to emphasize, a lot of people don't realize this, that the Right to Try Act, which is at the heart of our particular project, was signed into law by President Trump and was something he was very proud of, and I believe still is. Yeah. And so this particular flavor of a push has all the support that you could imagine from every political angle, all the way through, we hope, HHS and up to the White House. We have at least hope that that's the case. And one other thing that I wanted to say is that a lot of times people look at the movement that's going on at the state level, which has always been totally opposed by the federal law and federal agencies. And then they look at the federal side and it's all FDA approval and they see that as pharmaceutical. And sometimes they see these as an opposition. And in maybe some ways they are. I'm not here to try to, make people think that everything they've ever heard is wrong. But in the bigger picture, there's no way for policy change to happen in the way that any of us want without federal stakeholders involved and without getting our law rational top down. And so I'm not saying that people should abandon state level efforts. I'm not in any way suggesting that, or that they haven't been extremely important. What I am saying is this opportunity to make a real change to the way that drugs are classified under federal law, and in a way that would immediately get access to people who need it most, at a time when we have support both, in the White House and Congress, and the agencies. It is really, really unusual if you're familiar with the history of the war on drugs and with drug scheduling under the Controlled Substances Act. It's an exciting time, and we're either going to look back at it as I think a pivotal inflection point when things started to move in the right direction, or as a major missed opportunity. And so Kathryn would have stopped it without the major missed opportunity point. I, as the sort of more cynical and I guess always preparing for a rainy day lawyer, and see both parts of that. And I just really want people to rally around not just this effort, but the entire movement right now, and not see us as divided, because we're not.
Yeah. Well said, as always, Shane. And again, I think as we've seen certain Republicans float the idea of pushing to reschedule ibogaine, I think this is a good pivot point. If in a hypothetical but seemingly promising alternate reality, your petition is seen through, the HHS makes a recommendation that yes, Schedule 2 makes sense. Maybe they go even farther. Do you imagine that there will be a wave of similar scheduling petitions? Have there been discussions of pushing this forward as it comes to other designated breakthrough therapies like MDMA? And I don't think that ibogaine has received breakthrough therapy status yet. I don't think I'm wrong about that. But with promising research and significant conservative support right now, it seems like a no-brainer to move interest there forward as well. What say you?
Well, I'll say that I think it's also worth mentioning that not only, does President Trump take great pride in the signing into law of right to try, but we have heard from a chorus of federal agency leaders in reported statements their support for opening access to psychedelic assisted therapy as soon as possible. Yeah. And the fact that our petition is now queued up and is a very strong petition supported by the science and the medicine, it is queued up and ready for action. It offers those federal agency leaders and this administration the gift of being right there in the queue, ready to be acted upon. So while there may be, and different leaders have different support for different psychedelics, the fact of the moment, the opportunity of the moment is our petition is queued up and it's ready for action. So for any federal agency leader at this moment wanting to see psychedelic assisted therapy made available, the quickest path to that is favorable action on our petition.
Yeah. So Shane, you obviously mentioned that there
and
would
if
be
I could add something, Jack.
Of course. Jump right in.
Sorry,
no worries.
There's got to be some sort of delay.
No problem.
I wanted to say, you mentioned, would this open a door for potentially other reforms? And absolutely it would. It's an important point. This would establish a pathway for drugs that can establish currently accepted medical use with severe restrictions to move to Schedule 2 for this pre-FDA approval access. That would be huge, not just for psilocybin, but for, as you mentioned, other drugs that are currently in the pipeline. And, I heard this the other day from a reliable source. I haven't confirmed it myself, but that currently the INDs for mental health indications, over 50% of them are for psychedelics right now, which is, kind of amazing, staggering. And it just shows that there's sort of a dam here with a whole lot of momentum behind it. And that momentum is there because of the promise that these drugs have proven scientifically to help people who are unnecessarily suffering. So it's a worthy cause.
One of the areas I guess I want to hone in on, bringing it back to the Right to Try Act as we start to wrap up. We have about 5 minutes left for those tuning in. We've seen really promising psychedelic research by any scientific standard into areas other than what we hear about often in the mainstream media, i.e., PTSD or treatment-resistant depression. Things like postpartum depression specifically, things like irritable bowel syndrome, things like OCD. And even in some cases, like one UCLA study, from my understanding, concluded for use in treating bipolar disorder. What, in theory, now that the, dying, patients aspect of this is fully in care, palliative care is front and center with this petition. Do you imagine right to try being able to be utilized? And hey, there's a really promising new emerging area of research for, any number of areas when it comes to psilocybin. We'd like to try under that. Could patients go to their doctor and could they cite that this is research and they'd like to try this drug? What would that process look like?
Yeah, I mean, I think that we are forging the path. We're forging the path both to the rescheduling of psilocybin off of Schedule 1, and we're forging the path to right to try access to controlled substances prior to FDA approval. And so, once a path is forged, others can certainly follow it. And so, that's really been our task here. And, I would be remiss if I didn't share with your audience that those who are interested and excited and supportive of this work can support it financially. It's all been funded through philanthropy. That's fallen on relatively few shoulders. And the importance, the catalytic nature of this work to change the landscape is so potent that we'd really like to see others come in and support it. Some of the work has been pro bono, but some of the work obviously is funded, and those of us working on this really appreciate support to get this across the finish line. So those donations can come in at the 501c3, that is the National Psychedelics Association Foundation.
And we'll be sure to include information about NPA in the show notes, and hopefully doing some more NPA related reporting in the near future as well. Shane, curious to get your thoughts on, one on those boundaries again of the Right to Try Act, but also we know that the public comment period will open up at some point. Folks need to be prepared. But after that ends, how quickly might we expect, I guess this is where we can wrap up with this question actually, how quickly can we expect the HHS to move forward on actually reviewing those public comments, the evidence that exists, and offering some sort of recommendation? Is there a timeline?
Right. So first, the HHS's analysis will come in before there's a public comment period. So what would happen would be we have to wait for HHS's analysis, which could be, we hope, much faster than in the cannabis context, for example, because the science is already very much at hand and so forth. Then there would be the time for DEA to write a proposed rule. That takes some time, but it's pretty straightforward here because of the nature, how clear the science is, and because it's very much established. Mm-hmm. At the point that the proposed rule hits the Federal Register, there will be a 60, 90, I forget exactly what it is, day period for public comment. Okay. That is the time window when people need to be prepared, and they'll have the analysis in front of them so that they can review it and weigh in on it. And at that point, there will either be public hearings or not. Once all the public comments are in, DEA has to respond to significant ones and draft a final rule, doing whatever it's going to do, hopefully moving psilocybin to Schedule 2.
Yeah, so in this case, a hearing would be necessary either in the event that recommendation is something that is not Schedule 2, keeping things as status quo. In that sense, you all and maybe whoever else would petition for a hearing, correct?
So I'm still having trouble hearing. I really apologize, but I understand what you asked to be like, when is the hearing necessary? A hearing isn't necessary. What's necessary is an opportunity for a hearing. Historically, DEA rarely grants hearings in the scheduling context.
Yeah.
There have been hundreds of scheduling actions. There have been, I think fewer than 20 hearings under the Controlled Substances Act. So that's really unusual, but they could. And it will depend on the nature of the request for hearing that they receive.
Yeah, and I'd be remiss not to note that, having covered last year's DOC hearing, that was actually the first scheduling-related hearing about any psychedelic compound since 1985. So there is precedent, obviously, in the last 365 days that a hearing on such a rescheduling order, has been heard. But that was because a group came together to fight against something being labeled Schedule 1. Not in defense of rescheduling. So Definitely curious to see how that plays out. We're at an hour exactly, so would love some closing
And Jack,
thoughts.
just one note on the night.
Go right ahead, Shane. Can you hear me?
Yeah, so just that 1985 hearing too. Can you guys hear me?
Yes,
Sorry
we can
about
hear
that.
you. Yes, sir. No worries.
Just on that 1985 hearing, it's important to note that if I'm not mistaken, that hearing was ordered by the DC Circuit when DEA refused to move forward with the petition. I believe it was MDMA, if I'm not mistaken. And so that was forced. DEA didn't want to have that one. So in your list of precedent for this happening, DOI DOC becomes even more remarkable in light of that.
Truly, I think it's one of the most underappreciated and I think most important legal battles in drug policy, especially because it, despite having covered it and seen the case that was put on, was a flimsy case by the DEA at best. It still was moved in the direction of Schedule 1 based on the recommendation. You'll be hearing some more coverage about that in the near future from me. But knowing that we're in an hour, would love to get both of you any closing thoughts on one, what this case means to you, but two, again, how people can support. Where can they learn more? Where can they find more about your work, whether it's in this case or elsewhere? Kathryn, you mentioned NPA, so we will.
Please support the work. You can be in touch with me. You can be in touch with the National Psychedelics Association. I think what we're talking about here and what I've been laser focused on is bringing a really potent new palliative care tool to the bedside for people with life-threatening conditions so that they can have relief from debilitating anxiety and depression and have a much more peaceful, resolved last bit of this lifetime. And that's hugely important to the individual, to the families, to the culture at large. So we're on that road. We're fighting this fight. We'd love to have your support.
Shane, any closing thoughts for the folks at home? Hoping you can hear us. Shane, can you hear me okay? Just want to get any closing thoughts you may have. We may have lost him. We will certainly include information, about both Shane's practice and any updates that come along. We'd obviously love to hear from you both with any updates that are to come. Shane, hoping to get some final thoughts from you, my friend, before we sign off here. Can you hear me okay?
Modern technology.
You can hear us. Anyways, I will.
Thanks for hosting this, Jack. It's been a pleasure to be with you.
Yes, ma'am. Thank you so much, Kathryn. And I will close us out with just some closing thoughts. So grateful to all 152 of you strong that have signed in and signed on to tune in today. We'll be making some exciting announcements in the days ahead about how we're taking Psychedelic States of America to the next level with these partnerships we've forged with the folks at High Times, Psychedelics Today, Lucid News, and many more to be announced soon. I'd be remiss not again to thank High Times Magazine for joining us as our exclusive co-live streamer today. Really an honor to follow in the footsteps of so many phenomenal reporters who've contributed to High Times previously. And we really hope that this partnership with Psychedelic States of America can burgeon in a new standard for drug policy and drugs-focused journalism in the years to come. So without further ado, signing off for Psychedelic States of America and our Advocacy Spotlight Initiative, I'm Jack Gorsline. See you all next time.